Okay, during this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone will have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it is usually based upon a percentage of the bond. Finally, if you use property to post a bond, the property will need to have a net equity at least 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise their right hand, please. Do you swear or affirm any statements made during this proceeding will be the truth, the whole truth, so help you God?
Yes.
Okay, let's proceed with Mr. Cleaver's client, Mr. Moody, Charles Moody.
Where's my back?
Okay, Mr. Moody, normally I would address you during this proceeding, but since you have a lawyer present, Mr. Cleaver, I'm going to address all of my questions to him. Please understand that anything you may say during this proceeding is not private. So if you need to say something to Mr. Cleaver, unfortunately, we don't have the ability to put you in a breakout room. So don't say anything unless you want the whole world to hear that, okay?
Understood.
Okay, Mr. Cleaver, Mr. Moody has been charged with criminal trespass, damage to property, and battery. I've set a preliminary bond, total bond of $8,000, and I put a stay away provision on the bond to stay away from Tawadnija Gibbs. But I'll hear from you, sir, as to anything you want to address to the court as it relates to his bond.
Thank you very much, Your Honor. Your Honor, Charles Moody comes before the court, born July 31st, 1979, resides at 539 Palmetto Oaks Trail in Palmetto, Georgia, zip code 30268. He has extensive family and friends here in Georgia, has a child, Colin Robertson, age 6, has an associate's degree, and has worked at the company Alstom, ALSTOM, for the last 19 years, working at the Atlanta airport, Hartsfield-Jackson. He's charged with misdemeanor charges on this case. He comes before the court, I believe, with only one prior criminal conviction in 2009, a misdemeanor marijuana charge to which he pled nolo contendere, served his sentence, has no history of violating probation, has no history of any bond issues. And Your Honor, regarding some of the factual details of this case, Mr. Moody got into a dispute with his girlfriend, as the court noted, Miss Twanye Gibbs, spelled Twanjia, last name Gibbs. Miss Gibbs, we believe the evidence would show, attacked Mr. Moody, and in order to de-escalate the situation, Mr. Moody left the property. A neighbor called the police. Miss Gibbs makes statements to the officer which would incriminate Mr. Moody. However, the very next day, Miss Gibbs goes to the Clayton County Police Department, makes a voluntary statement that she lied to Officer Milligan, the investigating officer, and she was immediately arrested for making a false report of a crime. So, Your Honor, given Mr. Moody's ties to the community, his history of working diligently to support himself and his family, and the specific facts and circumstances of this case, that Miss Gibbs, the alleged victim, on her own volition, went and confessed to the crime of making a false report against Mr. Moody, we would ask the court to consider an unsecured judicial release on the matter. We appreciate the court setting a bond amount, which the court put in place, and we understand the reasonableness of a no contact order, but we would ask the court to reduce the court's bond amount to that unsecured judicial release, or in the alternative, no more than a $2,000 bond on the matter.
Give me 1 second.
And Your Honor, one last thing I forgot to mention, sure. Mr. Moody did turn himself in on these warrants as opposed to being picked up on them. I have no doubts that Mr. Moody will appear before the court at any scheduled court appearances, and I know we're doing a lot of these things remotely, so that lessens the burden for him to appear. We believe he satisfies all of the Ayala factors.
Yes, and he's charged with the misdemeanor, and you're correct. It looks like he has just one prior conviction or arrest. I am looking up Miss Gibbs for the moment. I am now doing a number of these hearings. The first appearance hearings, that I have noticed a couple warrants written for false statement.
Your Honor, unfortunately, Madam Solicitor Audrey Lewis was unwilling to quash the warrant, although she reviewed and had her concerns. But that's why, we wanted to make sure we came before the court and presented this information to the court. We think it's relevant to a bond determination, the fact that Miss Gibbs said what she said to Clayton County Police and was immediately arrested for making such a report.
I would tend to agree with that. Hmm. I do see that there is a warrant taken out for her on March 13th.
I think the date of this alleged incident, Your Honor, was March the 10th. So it would have been
Yes.
shortly after the initial report.
Okay, what I am willing to do, I am going to keep this stay away provision on, but I'm going to reduce this bond. For the criminal trespass and the battery, I'm going to reduce the bond down to $1,000 on the criminal trespass and $1,500 on the battery. I'm going to make a notation that Ms. Gibbs is charged in, looks like the warrant is 2021 WA 0622. Yeah, it looks like it's 062222 is the warrant that she's charged in with the false statement. The problem as it relates to some of these things, I wish that they would have a prosecutor here and these kind of issues can get dealt with more deeply. But at least having you here to advise me of this has helped. So he's going to have a total bond set at $2,500. And the reason I made the comment that I just made is that the unfortunate thing of going back and forth, we see things on both sides of people making statements and then bringing a statement back or making, so it just becomes a big circular kind of issue. So it looks like the best place for this to get dealt with is going to be in state court, but at least he's going to have a bond that reflects the fact that there's a possibility that this was not, that this did not happen.
Thank you very much, Your Honor, for your consideration on that.
Okay, is there anything, he's going to currently has a preliminary hearing date set for May 11th, but that date will get waived upon bonding out and he'll get a new court date in the mail. Do you know why the solicitor didn't consider withdrawing the warrant?
She didn't state specifically. I just wanted to do my due diligence in presenting the matter to Madam Solicitor to see if we can avoid the necessity of having this case proceed on an actual criminal calendar, but
right. Okay. Is there anything else?
Your Honor, you said May 11th for that preliminary hearing date?
Yes, at 8:30 in the morning, and currently it'll be by Zoom, but who knows what will happen by that time. But upon his bonding out, there's going to be a new court date set. So if he bonds out, that May 11th date is going to get waived and he'll get a new court date in the mail, or you should get the new court date in the mail.
Yes, Your Honor. And what's the best way to get the court's bond order?
I actually have a pre-printed bond order. So when this hearing is over, I send the paperwork back over to the sheriff's department and they input the information. So he at least will know he has a bond amount set and he can start making his arrangements as it relates to bonding out.
Thank you, Your Honor. Is there a contact information just in case there's some delay? Sometimes with the sheriff's office, they don't necessarily have everything to maximum efficiency. So I just want to make sure if they're in the event of delay, I can reach out to the court to make sure everything, the chair said
My
everything.
email is brad.gardner, Gardner, at claytoncountyga.gov. But a lot of times the delay is probably on the judge's part because I do everything. I've been up since 7 this morning working on all of this. And then after the hearings are over, I send the paperwork back over. So a lot of times the delay is based upon the judge getting the paperwork to the sheriff's department.
Well, Your Honor, we certainly appreciate your hard work.
Okay. Well, if there's nothing else, you are free to go, Mr. Cleaver. And Mr. Moody is free to go back.
Thank you, Your Honor.
Okay, let's deal with Mr. Ray, Kenneth Earl Ray. Okay, Mr. Ray, you're in the same position as Mr. Moody. I would normally speak to you directly, but since you've hired Mr. Barber, I'm going to direct my questions to him. And just be aware that anything you say in this proceeding is not private, so don't say anything that you don't want the whole world to know. So, Mr. Barber, what I have here is one warrant for hit and run. And I've preset a bond for $3,000 for this, but I'll listen to you as it relates to anything you want to address to the court as it relates to bond for your client.
Thank you, Judge. Mr. Ray was actually arrested from this incident on March 12th by Morrow Police Department and made a bond that day with City of Morrow Police Department for the other charge, disorderly conduct. I have no idea how these cases got separated, but
Okay.
he even has a court hearing in Morrow on April 7th for this. I can share my screen so that you can see the warrant information if you would like, but he currently has $1,000 bond out of City of Morrow for the charge that goes with this of disorderly conduct. And I don't know why these got separated. I don't know how they got separated. But as far as for the bond purpose, let me just give you some information. He actually has two jobs. One of them, works for Signature Staffing. He does temp positions and general labor. That is a part-time job. He owns his own painting business called Ray's Painting. He goes to church at Tabernacle Praise in McDonough. He is actually a pastor and gives sermons. He assists with the homelessness in downtown Atlanta, and he has various friends and family in the area, including his mother, who lives in Hampton, Georgia. So I definitely think that he meets the Ayala factors. Given that he has already paid a bond out in City of Morrow, we would be asking for a sign-on bond on this one, even though it's hit and run. I could go into the details as to why it's not hit and run, but that's not appropriate since you don't have a prosecutor here to say, well, that's not really how it happens. So, right. But we would be asking for a signature bond today, Judge. Would you like me to email you a copy of the city appearance bond or share my screen?
Well, you can share your screen. I'm looking at the warrant that I have before me for the hit and run, and it was actually taken out by Lake City and not Morrow. So that may be how this got separated.
I don't know, but all I know is that it's from the exact same day. And Mr. Ray informed me that, okay, so his rendition of it was there was an accident, there was a rear ending, and he pulled across the street to a Walgreens. And when the police showed up, they wrote him up for disorderly conduct for whatever reason. I guess he got in a fight with them or something. And they said, he left the scene. Well, he only got the disorderly conduct. So he actually spent 3 days in the hospital because they took him to the hospital before they took him to the jail. And it turned out he had a concussion. Right. Here is a copy of the bond from this. Share screen. There it is. So here is a copy of the bond that he made from that. You can see it's March 12th, which is the date of the accident. And he paid $1,000 on the bond. out of, and it says City of Morrow on it. So I don't know how Lake City, as I said, I don't have the information on the report or anything, so I don't know how Lake City got a hold of it for a warrant for them if everything happened in Morrow.
So it looks like there's a state charge that's being written on this hit and run 40-6-270,
Right.
and it does reference the incident date of March 12th.
Right.
So,
That he didn't make bond till March 13th. The incident did happen on March 12th for this one, and it was jam. He's got a bond with jam bonding for it.
yeah, I mean, I hear and I understand your argument. I know that Lake City and Morrow abut each other as it relates to jurisdictions.
Okay.
And theoretically, there's an accident.
Right.
You drive over, you pull over, and now you're in Morrow's jurisdiction as opposed to in Lake City's jurisdiction. And instead of the officers discussing, they just get upset with him and arrest him.
Right.
Disorderly conduct. It seems like the next morning on the 13th is when this Officer Ramos from Lake City went to get the warrant for the disorderly conduct. I'm sorry, the hit and run.
Right.
So what I'll do is this, Mr. Barber, I'll set your client a bond at $1,500 on the hit and run. And he'll have a preliminary hearing date set for May 11th, but that date again will get waived upon his bonding out. I mean, it looks like the way that this probably can most efficiently get joined is that he waive over from Morrow to the state, and so that these charges are then joined. But that's, of course, a decision that you would have to make as his lawyer. It may be more advantageous to deal with both of these separately. I don't know.
Well, they both stem from the same interaction. So to me, they are the same case, which is the only reason that I was asking for a signature bond, since he's got a city appearance bond already on the accessory charge with it. I mean, it's a Fulton DeKalb issue is what it is. It's probably on the road like Fulton and DeKalb has, where Glenwood separates it. This road probably separates Lake City and Morrow.
Right.
And like you said, I mean, he got arrested by Morrow, and he should have been arrested on the hit and run at the same time. And that is not my client's fault, which is why we were asking for a signature bond on your case. Regardless of what happens, he's still on bond in Morrow. So I know that as far as Clayton's concerned, they're not related because it's two different types of bonds. But I understand.
So theoretically, if he was arrested on the disorderly conduct and the hit and run, I would be required to place a bond on each.
Correct.
So, I mean, I understand what you're saying, you know, and I'm still a criminal defense lawyer. I'm part-time here. So I do understand that it's better when things work in a proficient manner and it's not just one person deciding to do what they want to do because they can. So yeah, so I do understand what you're saying. I mean, because I understand and I do sympathize, and that's why I reduced the bond down. But just so you know, as it relates to a signature bond or anything like that, our current policy is that we would have to go through my chief. So if I were asking for a signature bond because she's doing TPO hearings, he'd probably have to sit in jail an extra day to get an answer as to whether.
He's shaking his head now.
Yeah. So if there's not anything else, then I will let you go.
I will, just so I can tell him, I will let your wife know what happened. and she'll come get you, okay?
All right, thank you.
All right. No, I don't have anything else, Judge. I do thank you for your patience and allowing me to pontificate and expound on my theory. But that concludes my business at this point.
Hey, you're free to go, Mr. Barber. It was good to see you.
All right. Thank you, Judge.
And you're free to go back,
Thank you.
Mr. Ray.
Go ahead.
Okay, let's switch over to the lady side.
Excuse me, Your Honor.
Yes, sir.
Can you finish one more person for me so I can take him back?
Sure.
Thank you.
Who is the person?
It's gonna be Carter. It's coming right now.
I'm sorry, I didn't understand the last name.
Go give me.
It's Carl.
Did you say Hall? H-A-L-L?
Nah, Carter.
Carter.
C-A-R-T-E-R.
Okay.
Man, y'all out there doing it, no reason.
Mr. Carter, you're charged with one count of battery, one count of theft by taking motor vehicle, and one count of theft by taking. You're going to have a total bond set at $27,000. Do you believe you can post that bond?
Yeah, I can post that bond.
Okay, and there's going to be a stay away provision on this bond to stay away from Kajia Lawson, K-A-J-I-A Lawson. Do you understand that, sir?
Yes, I understand. I explain something to you.
Now,
I'm gonna let you finish.
I'll say this. Anything that you say to me is going to be posted on the internet worldwide. So if you want to say something, you're free to say it. I'm sorry.
So, so as you see, we all sitting here right now. As you see, we are.
Anything else, Your Honor?
Hold on one second. Let me finish this with Mr. Carter, and then we'll see. Mr. Carter, you're going to have a preliminary hearing date set for May 10th at 8:30 in the morning.
Are you good? You good?
Hold on one second. Do you want me to see if you qualify for the appointment of a lawyer, or are you going to hire your own lawyer?
No, I got a lawyer. I'm good.
Okay. All right. You're free to go back, Mr. Carter. Okay. Now let's switch over to the ladies' side, and we'll do Miss, what was that, McGee?
Your Honor, can we do Ms. Johnson next? Because, yeah, she gotta go back to medical. Ms. Johnson.
Yes.
We do her next after Ms. McGee.
Okay.
Can you hear? You hear, right?
I can try to read, if he take his time, I can read his lips, okay?
Just go slow with her, Mr.
Okay, I will. Ma'am, can you understand me?
Okay, I can.
Give me 1 second. I have to pull up your paperwork, okay?
Okay.
Yeah, she next, right?
Okay. Ma'am, you've been charged with one count of simple battery.
You next,
I'm
all right?
going to
Going
make
next
a
after that.
bond at $2,000. Do you believe you can post that bond?
I'll take your hands out your shirt.
Okay, you saying that I'm charged with one count of simple battery, right? One count simple battery, and you said it's $2,000, my bond, right? Is that what
Yes.
you're saying? Okay,
Yes, ma'am.
so are you asking me?
Can you afford that?
Can I afford $2,000? Yes, I can. I can.
Okay. There's going to be a stay away provision to stay away from Cheyenne McGee.
Sir, may I say something here? Okay, I have no problem. Cheyenne McGee and her mother lives in my house. That is my residence, okay? Cheyenne McGee and her mother attacked me first in my bedroom. Her mother came in. I only was inquiring about a situation that happened the other night. She had about several uh, people over there. There was guys and 3 o'clock in the morning at my household. I questioned the issue, okay? Her mother told her to go in her room. And I said, Cheyenne, I asked you a question. People are complaining about it. I had neighbors come and complain about the cars laying around and they asked me, was I having a party? No, sir, I was not having a party. Cheyenne is 18 years old. She was having a party. I have talked to Cheyenne over and over again about this situation. I also reminded Cheyenne and her mother, this is not your house. When your mother get her own house, then you can do as you choose in your mother's house. But you cannot do what you want in my house. Her mother came in my room. Her mother's room was down there by the kitchen. She had to walk all the way down the hallway to my room. Her mother came in my room and cursed me out, and she hit me. Okay, Cheyenne was standing in the doorway, and when I told her I need you all to get out, I said, I'm going to get an eviction notice tomorrow, and I want you out of my house. That's quite upsetting my daughter. And my daughter slammed my door. She and Cheyenne was standing inside of my door. They took the doorknob and locked me in my room, closed the door, held the doorknob in my room, okay? So I stayed in there and I laid down. I called.
Excuse me, not to cut you off.
No, he needs to know.
But he's not here to try the case. He can't say if
but it's my house, and I can stay away from Cheyenne, providing he give me an order for them to stay away from me. They need to move away from my household. It's I'm requesting for you today for that to happen.
Hold on, stop.
Okay.
So my hands are kind of tied in these situations.
Mm-hmm.
You made the decision to allow them to stay in your house. If they are now acting in a manner that you believe you need them out of your house, you have to take lawful recourse. So, because she's listed as a victim, I cannot force her out.
Well, your mother told me the bundle Cheyenne raised her fist to hit me. So what do I supposed to do? I didn't hit Cheyenne back.
Call the police. Call the police and report the crime. I can't jump into your house and manage your household. And I know that that may sound harsh, but my hands are pretty much tied that I cannot force a victim out of a house that they were allowed to stay in the day before.
Sir, what I'm asking you, so you're saying that I'm going to have to leave what I paid for, that I worked hard for and paid for, and give it to Cheyenne and her mother needs to get a place for her and her daughter. That's all I'm asking for, you just for them to move out of my house to give me. I have a 10-year-old son to raise, okay, in my household with me. And so I'm going to give Cheyenne, 18-year-old, the credit to take over my household and live in my household. And as simple as that. Is that right? Is that what you're telling me that I should do?
For the moment, yes. So let's reverse the situation. Let's say that you are married to me, and then I beat you up.
Mm-hmm.
But you're living in my house. Do you think it's fair for the judge to then tell you to leave? Because I beat you up and that's the allegation? Not that you did it, but that's what's going on right now. So that's where my hands are tied. I would encourage you not to make this decision in the future to have someone living in your house that you either are not going to abide by your rules, or they're going to be so unstable that they will have you arrested.
I don't have anywhere to live, sir, but in my house. I am retired. I am on Social Security. This is all I have.
There's not much that I can do other than I can appoint a lawyer to represent you, and the lawyer can take those steps that are necessary to assist you. Would you like for me to do that?
I would appreciate it.
Okay. Okay. I am going to appoint a lawyer to represent you. I can't find that form right now, and I don't want to sit here and have everyone waiting. I'm sorry. So I'm going to appoint a lawyer to represent you. You're going to currently have a preliminary hearing date set for May 11th, but that date will get waived and you'll get a new court date in the mail. I would encourage you to attempt to get a temporary protective order or to start a dispossessory process. But that is even complicated as it relates to now because of the COVID stuff. And so it's a tough position that you find yourself in. And I do have compassion for the situation that you're in. But as it gets to this point, my hands are kind of tied. I hope you understand that. Okay. You're free to go back, ma'am.
Go on, Mr. Mark McGee.
Wait a minute, hold
No,
on. Sir,
let's go.
I need to ask him a question.
No.
What's the question? What's it
I
going
need to
on?
ask him one
Ask the
question.
question. Ask the
Okay, I
question.
can.
Yes, go
Okay,
ahead.
sir, this is what I need to ask you, okay? It's not that I have not tried to get them out of my house. I came down here
No,
several
no,
times.
ma'am.
No, you need to know this.
No, no, ask
Because he said I didn't
No,
try.
sir,
Okay,
no.
forgive me, forgive me.
Okay, yeah, go. Yeah, go.
Can I go?
You wanna stand up?
Thank
What's your
you,
name?
God.
This is Miss Johnson, y'all.
Okay. Are you Wanisha Johnson?
Yes, sir.
Okay, ma'am, you've been charged with one count of theft by conversion as it relates to an automobile. You set your bond at $10,000. Do you believe you can post that bond?
Yes, sir.
Okay, you're gonna have a preliminary hearing date set for May 10th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Ma'am, are you currently employed?
No, sir.
Okay, you're going to qualify for the appointment of a lawyer. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Deputies, give me 1 second. I'm going to put these forms in order. If not, we'll be here for 3 hours. Hold
Okay.
on.
Yes, sir.
Okay, I'm ready to start back up, but I think I am missing some of these forms. But we'll get through it. All right, are we ready to go in order now on the lady side?
Yes, yes, sir. Yes, sir. So
Okay.
next is going to be Miss Dickerson. Hey, y'all holding on.
Okay, Ms. Dickerson, ma'am, you've been charged with 1 count of criminal trespass, damage to property. I've set the bond at $5,000, but I've also put a stay away provision on the bond to stay away from a Taya Harris. Do you believe you can post this bond, ma'am?
Yes, sir.
And do you understand stay away provision?
Yes, sir.
Okay,
Huh? That's you.
you're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning. That date is gonna get waived upon your bonding out, and you'll get a new court date in the mail. Are you currently working, ma'am?
No, I'm in externship.
Okay. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, I'm gonna find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me, ma'am?
No, sir.
Okay, you're free to go back.
Next is Miss Dempsey.
Okay. It looks like what may have happened is I don't have the ones from the ladies' side. I don't think I have any of the forms for the ladies. Ma'am, you've been charged with 1 count of battery. I'm gonna set a bond at $5,000. And I'm gonna put a stay away provision on this bond to stay away from Lakeisha Collins. Do you believe you can post that bond, ma'am?
Yes, Your Honor.
Okay, do you understand the stay away provision?
That's my workplace. I'm working there.
So does Ms. Collins work there?
No, I'm working there. I'm a cashier.
Okay, so it's a stay away provision to stay away from Lakeisha Collins, not to stay away from your job.
Okay.
Does Ms. Collins work in the same place that you work?
No, she's just a customer.
Okay, so you can go to work.
Mm-hmm.
You can't go to Ms. Collins' house. You can't follow Ms. Collins. You can't be around Ms. Collins. You can't contact Ms. Collins. Do you understand that?
Yes, sir.
Okay. You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, but that date is going to get waived upon your bonding out and you'll get a new court date in the mail.
Okay.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
How much do you make per hour, ma'am?
$11.50.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, what about she come to my workplace? What I'm supposed to do?
Do not have any contact with her. Do not serve her. Have someone else deal with her.
Okay.
Okay?
Okay.
Any other questions, ma'am?
No question.
Okay, you're free to go back.
Thank you.
You're welcome.
Next is Miss Huff.
Okay. Ms. Huff, you've been charged with 1 count of criminal trespass. I'm going to set the bond at $3,500, but I'm also going to put a stay away provision on the bond to stay away from Jaya Turnipseed. You believe you can post that bond, ma'am?
Yes.
Okay. Do you understand the stay away provision?
Yes.
You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, ma'am?
No.
Okay, you qualify for the appointment of a lawyer. I'm going to appoint someone to represent you. Do you have any questions of me, ma'am?
No.
Okay, you're free to go back.
Next is Miss Harley.
Okay. Give me 1 second, ma'am. Okay, you're Miss Hurley?
Yes.
Ma'am, you've been charged with 1 count of criminal trespass. I'm setting a bond at $3,500, but I'm putting a stay away provision on your bond to stay away from Tia Hurley. Do you believe you can post this bond, ma'am?
Yes, can I ask you a question about that?
Yes, ma'am.
Because actually, I just like slapped the wine glass off the table. It was no threat to her. She even told the police that. But I actually drove away from the scene, went to a hotel up the street, called the police myself, had them come back to the house because I wanted the children out the house. This has nothing to do with me and my wife, really. I wanted the children out the house. So I brought the police back to my house and they asked what happened. I told them that I, slapped the wine glass off the table, no threat of anybody to nothing. They asked could they come in the house to see the wine glass. I allowed them in. When they saw the wine glass, they put me in cuffs. But it was no threat to me, my wife, none of that. I had them come for the kids to be removed from the property.
So The unfortunate thing about this is that at this stage, technically, what you told them you did is a crime. And I know it seems like it's really minor and it's a misdemeanor.
No, I'm not saying that it's minor, but what I'm saying is it was not a threat to my wife. Like, she wasn't even holding the glass. The glass was like on one side, she was on the other side. It was no threat. And we both reside in this property, and she don't feel like she's a threat. She tried to tell them last night, not to even.
She can contact the solicitor's office and let them know that she doesn't feel that you are a threat to her. The problem for someone like me is I wasn't even there. So I have to look at what's written on the paperwork. And so I don't know if this was just, you know, another night for the two of you, or this was something that was out of the ordinary. So the reason we put a stay away provision on is that we don't want, if this was a situation where this was really about to get a heated thing.
I was gone, sir.
Let me finish. We don't want whatever led to the police being called last night to come back up. So the two of you can kind of work this whole thing out. And honestly, unless the police need to be called in the future, when you invite them into your business, you're taking control away from your life and putting it in somebody else's hands. So if this is something that could have been dealt with in another way, you know, think about that next time. And if these children are there and they don't need to be there, they don't need to be there. Does that make sense to you?
Yes, that makes sense. But as long as she contact you guys and say that she told them last night, I mean, I'm sure that you could ask the officers that, but you know.
Right. And I can't, and that's the thing, I can't like just start picking up the phone and doing my own investigation. The officer has sworn in his warrant to what they saw, and I have to go by what they swore to in this warrant. So it's not her contacting us, it's Hurley. It's her contacting the solicitor's office, because this is something that the solicitor can agree to a modification of the bond condition and take it away or do whatever they want to do with it. They're the prosecutors. They're the ones that are going to make those decisions moving forward. My job is to just set you a bond, appoint you a lawyer, and kind of make sure that you can deal with this as quickly as possible. Do you want, let me see. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
Yes.
About how much do you make per hour?
It depends. You know, work is really slow, so about 17.
Okay, you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any more questions for me? Okay, you're free to go back.
Next is Ms. Jones. Hey, don't let the door close and leave us. Don't let the door close all the way.
Ms. Jones, you've been charged with possession of marijuana less than an ounce, tampering with evidence, an open container, in a vehicle. You're gonna have a total bond set at $3,000. Do you believe you can post that bond?
Yes.
You're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning. That date is gonna get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're gonna hire your own lawyer? Or you gonna represent yourself?
I don't need one. I did.
Okay, you're free to go back, ma'am.
Thank you.
You're welcome.
Next is Miss Alexis Kirkland.
Ms. Kirkland, you're charged with 1 count of battery and 1 count of aggravated assault with a deadly weapon. Because you don't really have a criminal history, I've set a bond on the aggravated assault charge. You have a total bond set at $20,000. Do you believe you can post that bond?
Yes, I need to call my mother.
Okay. You're also going to have a stay away provision on this bond to stay away from Taja Jones.
I don't even know her name, but okay, yeah, I understand.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Ms. Kirkland?
I mean, I was. I don't know if I have a job now no more.
Okay. How much were you making when you were working?
I was working part-time at Amazon, $15 an hour.
Okay, you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Not really question. I mean, yeah, I do, but not really. I want to, yeah, I do have a question.
Okay, what's your question?
Real quick, if how did I get a charge if I was jumped and I lost my child during the fight getting jumped? I had a miscarriage due to all this. So how did they call the police and I get in trouble?
So right now, these are what's called mere allegations, meaning somebody said you did something. And what they said in these warrants, the police came to a judge to get these warrants on January 7th. And they said that you jumped on this Miss Jones and tried to pull her out of a car. And then the car hit her as you drove away. So that's the allegation. I wasn't there. That's why we appoint lawyers. That's why we do this stuff as quickly as possible so you can start defending yourself, okay?
Okay.
You're gonna have a preliminary hearing date set for May 10th. That date is gonna get waived upon finding out, and you'll get a new court date in the mail. So do you have any other questions for me, ma'am?
So right now I have a bond at $10,000. So right now I just need to call my mother and tell her that I got a bond and that's it, right? And I get out, or that's it?
Yes, ma'am. So I'm gonna complete the paperwork and be entered into the system today. You now know you have a bond. You can start making those arrangements through a bonding company or your mother or whomever, so that when this is entered into the computer system today, you can bond out and get out.
Okay, so how long does she need to go handle the bonds, or how long are you gonna take to put it in the system, or like?
So when I'm done here, I do the paperwork and send it back. So if I'm here for 10 hours, paperwork won't start getting done until 10 hours from now.
Okay.
Okay.
Yes,
Any other questions?
Nope. Okay.
Okay, you're free to go back.
Thank you.
Got everybody finished. Next is Miss Phillips.
Okay, ma'am, you've been charged with 4 driving related offenses: driving under the influence of alcohol, driving a vehicle with the concealed tag, driving on the wrong side of a highway, and an open container violation. You're gonna have a total bond set at $6,500. Do you believe you can post that bond, ma'am?
Yes, sir.
Okay, you're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, are you currently working, ma'am?
I'm supposed to start tomorrow.
And what is gonna be your starting,
13.
I'm sorry?
13.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
You said 6,500, correct?
Yes, ma'am.
Thank you so much.
You're welcome. You're free to go back.
All right, next is Ms. Williams.
Okay. Ma'am, you've been charged with 2 drug-related offenses and 1 possession of a firearm during the commission of a crime. I believe you've been charged with a similar offense as Mr. McDowell. You're gonna have a total bond set at $20,000. Do you believe you can post that bond?
Yes.
You're gonna have a preliminary hearing date set for May 10th at 8:30 in the morning, but that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Are you currently working, ma'am?
Yes.
About how much do you make per hour?
$11 an hour.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you.
Okay.
Do you have any questions of me?
No.
Okay, you're free to go back.
Thank you.
You're welcome.
That's it for the female genre.
Okay, would you do me a favor and just check and see what happened to the CAA forms for the ladies? Because I didn't get one.
Your Honor, I just checked on those, Deputy Mohammed.
Okay, thank you.
Check your email.
Well, I'm ready to get started on the male side. I have all of the male forms. I just don't have female forms.
All right, we're ready, Your Honor.
Okay. Are you Mr. Is it Asifal? Okay, sir, you've been charged with one count of violation of Georgia Controlled Substance Act, having a felony amount of marijuana. I'm gonna set a bond at $15,000. Do you believe you can post that bond?
Yes, sir.
Do you plan on it says you have your own lawyer?
Yes, sir.
Okay. You're gonna have a preliminary hearing date set for May 10th at 8:30 in the morning. The date is gonna get waived upon your bonding out and you'll get a new court date in the mail. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back. Are you Mr. Is it Babino?
Yeah, that's right.
Okay, sir, you've been charged with 2 drug-related offenses, 1 use or possession of drug-related objects, and 1 count of possession of a weapon during the commission of a crime. I've set your total bond at $26,500. Do you believe you can post that bond?
Yeah.
Okay. You're gonna have a preliminary hearing date set for May 10th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
About how much do you make per hour?
I don't work hourly. I'm self-employed.
Okay, about how much do you make per month? Just a rough average.
1,500.
I'm sorry?
1,500.
Okay, you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back.
Sit in the back.
You Mr. Boatwright?
Yes, sir.
Mr. Boatwright, you're charged with 1 count of criminal trespass and 1 count of battery. I've set a total bond at $7,500. Do you believe you can post that bond?
Yes, sir.
Okay, I've also put a stay away provision on the bond to stay away from Brittany. Is it to she?
Yes, sir. I got a question though.
Yes, sir.
It's my house, so I got to move all my stuff out of the house. I can't go back to my house to get my personal property and all that. Because she doesn't work. She doesn't work. I take care of everything. I pay everything. Pay all my bills, pay everything.
Okay, so 2 things can happen. Well, a couple of things. One, this stay away provision is going to stay in place until it's removed. Now, it can be removed, excuse me, it can be removed by the Solicitor General, meaning the prosecutor. If she says, look, I'm not afraid of this guy, you know, I want this stay away provision to be lifted, it can be lifted, okay? Until that is done, when you're bonding out, you need to make arrangements with the Sheriff's Department for them to come over so you can obtain some of your items for you to just be able to live every day until this whole thing is taken care of. You should not go back to the residence until you've made those arrangements with the Sheriff's Department. Do you understand that? You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Okay. You do qualify.
Oh, another thing too.
Hold on. I'm going to appoint a lawyer to represent you.
Again.
Now, what is it that you wanted to tell me?
I wasn't read my Miranda rights. when I got locked up.
Okay, that's something you need to talk to your lawyer about, because if you're not relying upon any statements that you made, it doesn't matter that you were not read your Miranda rights.
Hey, hold on.
Okay, you're free to go back, sir.
You said it's 7,500, right?
Yes, sir.
All right.
Have your name, sir?
Mr. Sean, Your Honor.
Okay. Sir, you've been charged with 1 count of aggravated assault with a deadly weapon and 1 count of criminal damage to property in the 2nd degree. Bond is going to be denied at this point on these 2 offenses, but you're going to have also have a stay away provision on this bond to stay away from Tariq Turner. I'm going to give you a preliminary hearing date that's going to be set for May 10th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. I'm going to also set a bond hearing date for, give me 1 second, for May 14th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Bowens. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Hey, Mr. Brooks. I'll take that.
Are you Mr. Brooks?
Yeah, can you see me?
Yes, sir, I can. Mr. Brooks, you're charged with 1 count of criminal trespass. I've set a bond at $15,000 on this, and I've placed a stay away provision to stay away from a Nyasha Lowry. Do you believe you can post this bond, Mr. Brooks?
Said 15,000?
Yes, sir.
Why is it so much?
Because of your criminal history.
Okay. Can you, please, can I ask you to reduce it? The simple fact, the day in question, me and Nyasha was talking, one of the neighbors called the police and she said I could come over there. So we was talking and one of the neighbors called the police. And that's the reason why I got locked up, because we was arguing loud. So,
right. I would, Mr. Brooks, you know, I have to set a bond on a misdemeanor. Let me see.
Yeah.
You have 15 cycles and you have some serious stuff that you've been charged with.
Yes, sir. But I'm trying to get my life together. I'm working hard, and I can't stay in here that long. Please, I can pay. Yes, sir.
Mr. Brooks, I have to. Basically, what I'm doing is making a bet on you, right? I'm making a bet that setting a bond, you're gonna get out and do what you're supposed to do. Not that you're gonna try to do what you're supposed to do, but you're gonna do what you're supposed to do.
I will.
No, I'm not reducing this, Mr. Brooks. I am not. I mean, you cannot just go through life doing this kind of stuff and just keep saying I'm gonna fix it the next time.
But she didn't call the police, sir. It was a neighbor, and I understand what I did in the past, but it's all like little stuff, and I'm really trying to. I haven't been in trouble for a minute, man. I'm really trying to get my life together. Please, like, you know,
I did see that.
5,000 a little bit too much for me right now.
No, Mr. Brooks, what I have to think about is when I look at your criminal history and then think about whatever you guys were arguing about, it was loud enough for a neighbor to call the police.
Well, it wasn't just on me, it was her too. We was both arguing.
Excuse me, sir. He's not here to try your case.
I understand, I'm trying to reduce my.
He's not gonna reduce it. You already done that.
I'm not gonna reduce it, Mr. Brooks. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. You're gonna have a preliminary hearing date set for May 11th. That date will get waived upon your bonding out. Now, if you're not able to make this bond, Mr. Brooks, your lawyer can contact the solicitor's office and they can work through this. I don't know what happened. I know the allegations. I know your criminal history. If there's other things that need to be taken into account, your lawyer can advocate on your behalf to get that done. Okay?
How soon is it till I get a lawyer? How soon is it?
The lawyer is going to be appointed today. The law firm is going to be Lister and Holt, Lister, second word Holt, Holt. If you don't hear from them by Friday, I would give them a call.
All right.
Okay, you're free to go back.
Next is Mr. Dorsey. No, I'm taking it back. Next is Mr. Combs. I'm sorry, Your Honor.
Okay.
Mr. Combs.
Mr. Combs, you're charged with 1 count of reckless conduct and 1 count of possession of firearm by a convicted felon. I cannot set a bond on the possession of firearm by a convicted felon at this stage because there's an indication that you're still on probation. I have set a bond at $5,000 on the reckless conduct charge. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date. I'm going to set a preliminary hearing date, a bond hearing date for May 14th. Now, you can get out before these dates. Your lawyer, if you want me to see if you qualify, I can appoint a lawyer to represent you. Okay, you do qualify. So I just can't set a bond for you at this stage. It doesn't mean that the DA's office, district attorney's office cannot consent to a bond before that date, okay? Do you have any questions of me, sir? Okay, you're free to go back.
Next is Mr. Costa. Mr. Costa? Costa, my bad. Go down.
Mr. Costin, you've been charged with 1 count of tenant window violation, 1 count of driving a vehicle with the concealed identity, and 1 count of driving a vehicle with either a concealed tag or the tag is for a wrong vehicle. I'm not setting a bond on the felony driving a vehicle with a concealed identity because it looks like this is the second time that you've been arrested on this charge. I have set a bond on the other 2 offenses at $500 each. I'm going to set a preliminary hearing date for May 10th at 8:30 in the morning. That date will get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
I was wondering if, you said I don't have a bond for the concealed tag?
For the felony, which is the altering VIN is a felony. 40-4-21.
Hey.
I'm sorry?
Hey. The vehicle, yeah, it's a misdemeanor.
Oh.
There was a conflict about that last night during booking.
Right.
It's a felony. 40-4-21B.
Right.
Okay, so they the VIN number that was on your car and the VIN number that was on the tag matched.
It said that, but okay. So it says that the tag showed VIN number. I can barely read this. Says the tag showed VIN number SALW R2RK1JA182490. It says the true VIN number is SALGS 3EF3GA290426.
So, I would like to know if you could set a bond for whatever you need to set it for, and I try to pay it today.
No, Mr. Costa, you also had a long criminal history, and you also have been arrested on this charge before. So
on altered VIN.
Okay, hold on.
I've never been arrested on altered VIN.
Hold on, I'll tell you.
The concealed tag, yes, but altered VIN never. I raised my 2 kids by myself. I got brain cancer. I got my appointment is April 14th. My next appointment is April 14th. Like, if you see, I haven't been in trouble since 2018. I haven't been in trouble. I don't get in trouble. Huh?
You have 10 cycles, which means you've had 10 interactions with law enforcement. The first in 2013 with aggravated assault.
Aggravated assault, which was I don't know if I pled guilty or not. I took aggravated assault, but it was with my family, it was my stepfather, etc. They came in there and I'm not sure if they dropped it or what the situation, but 2013, that was way then. Anything else was like traffic, whatnot. Clayton County.
So what I was looking at is January 22nd, 2019, out of Gwinnett County, by receiving stolen property, acquiring license plate for purpose of concealing identification of motor vehicle.
Yeah,
death by receiving stolen property. Oh, that's just the accusation date.
Yeah, and
so again, Mr. Costin, that's why it looks like also June 30th of 2020, out of Monroe County Sheriff's Department, the charge was affixing materials that reduce or increase light or transmission. That's a window tint. Yeah. Driving on suspended or revoked license.
But I got it all taken care of like I was supposed to.
So I'll tell you this. I'm not going to set a bond on this, Mr. Costin.
Judge, I have sole custody of my kids. I raised them by myself. I don't have nobody. Please, I will pay whatever I need to pay today to get out. I just need to get to my kids.
I'm not going to do it, Mr. Costin. I mean, you gotta make those considerations before you get yourself into trouble and have to go before a judge.
Judge, I got a car with VINs and the plates on it that matched each other. I didn't buy no stolen car. I didn't do it. Please, Judge, I'm begging you. I'm begging you.
No, Mr. Costin. Do you want me to see if you qualify for the appointment of a lawyer?
Yes. If I get a lawyer, could they get me a bond?
Yes. If everything you're telling me, I'm explaining to you why I'm denying the bond at this stage. You're telling me, look, all of this stuff matched. This is like some bogus stuff. This is the paperwork. This is what can show that this was wrong. Yes, you'll be able to get a bond and get out.
When does that work?
So you're telling me that everything on this vehicle is fine and straight. That means you have the paperwork. That it should be simple to get the paperwork and have that put together so that everyone can see that this was a mistake.
The VIN number on the car that I received and the tag that I got on the car matched the VIN number and the tag, sir. Yes. Yes. This time it wasn't no concealing. It wasn't a fake tag on the car. The VIN number that didn't match was what was visible on the window or on the door. I've been through, like you said, I've been through the situation before, so I looked to make sure that the tag and the VIN matched this time. I did according to what I know, my due diligence to the VIN numbers matching, so I wouldn't be in no type of situation. I wouldn't put myself in this type of situation.
So, Mr. Costin, if you live in Stockbridge, why do you have a vehicle with the Texas temporary drive-out tag?
Because I got on Terra Boulevard, I own the tax business on 7498 Terra Boulevard, and we got cars that my business partner is supposed to be selling here on the property, and they said we had 7 days or whatnot to register the car to Georgia.
Okay, so I would encourage you to get the paperwork together so that you can get this cleared up. But
if I don't have a bond, I can't get the paperwork to present what y'all need.
So, Mr. Costin, I'm not going to set a bond, okay?
Okay, sir.
All right, you're free to go back. Are you Jaden Dorsey? Okay, Mr. Dorsey, you've been charged with 1 count of criminal trespass, 1 count of disorderly conduct. I've set a total bond of $4,500. Do you believe you can post that bond? You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning. That date is going to get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back. Are you Kobe Dorsey? Okay.
Kobe, right? You want him?
Yeah, let me deal with Mr. Kobe Dorsey. So, sir, you've also been charged with criminal trespass and disorderly conduct, and I've also set the bond at $4,500. Do you believe you can post that bond? You're also going to have a preliminary hearing date set for May 11th. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify, Mr. Dorsey. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir? Okay, you're free to go back. Okay, now, Mr. Epps, you're charged with 1 count of battery. I'm going to set the bond at $5,000, but I'm going to set a stay away provision on the bond to stay away from Narendra Kumar Patel and 4552 Old Dixie Road, which is also known as the Home Lodge. So do you believe you can post this bond, sir?
Yes, sir.
And do you understand the stay away provision?
Yes, sir.
You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning. That date is going to get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. How much do you make either hourly or per month?
$2,500 a month.
Okay. You qualify, Mr. Epps. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Tell me your name, sir.
No.
Mr. Harold, you're charged with 1 count of improper lane change and 1 count of driving under the influence of alcohol. You're gonna have a total bond set at $5,500. Do you believe you can post that bond, sir? You said no?
Yeah.
You're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning. That date is gonna get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you qualify, Mr. Harold. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back. Are you Mr. Hughes?
Yes, sir.
Mr. Hughes, you're charged with 1 count of theft by receiving stolen property being a motor vehicle. I'm gonna set a bond at $20,000. Do you believe you can post that bond?
Yes, sir.
You're gonna have a preliminary hearing date for May 10th at 8:30 in the morning. That date is gonna get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Hughes. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
I don't have any questions, but I do have a statement.
Now, understand that everything you say is gonna be
I don't have anything.
okay. What's your statement, sir?
My statement is the tags that was on my vehicle, my car is registered and everything. I did get notified, and my girlfriend actually made she made the call to APD and told them about my tag being stolen, because I got pulled over, I got proof, I got paperwork. When I got the car and I was taking it to the Georgia Department of Driving Services, which I called them, and I was coming from Forest Park, I got pulled over at the Popeyes on 85. And I was trying to explain to the officer that I was trying to get my tag, and I was trying to report my tag stolen.
Okay.
My actual tag is stolen. CNJ 2020 is my actual tag. It was replaced. So that's all I have to say.
Okay. All right. Thank you, Mr. Hughes. You're free to go back, sir.
Good afternoon, Your Honor.
Good afternoon. Are you Javier Johnson? Sir, you charged with, looks like 3 driving related offenses, 2 driving related offenses, 1 possession of marijuana less than an ounce, and 1 use or possession of drug related objects. You're gonna have a total bond set at $4,000. Do you believe you can post that bond?
Yes.
Okay. You're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, that's okay.
Okay. About how much do you make either per hour or per month?
I have a self-owned business, and like I said, I make about 15 average monthly, so.
Okay, you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I will be able to pay post bail today.
Yes, sir.
That'll be it.
Okay, you're free to go back, Mr. Johnson. Are you Caleb Johnson? Okay, sir, you've been charged with 1 count of disorderly conduct and 1 count of criminal trespass. I'm gonna set your total bond at $4,500. Do you believe you can post that bond? You're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, I need the location.
You need, I'm sorry, what?
The location.
For okay. So right now, everything is being done by Zoom. So if you bond out, that date that I just told you will get waived, and you'll get a new date in the mail. If you're still in custody, they will bring you down like they're bringing you down now. Okay? So You do qualify for a lawyer. Did you say that you wanted me to appoint a lawyer to represent you?
Yes.
Okay. So I'm going to do that. If you don't have any questions for me, Mr. Johnson, you're free to go back.
Excuse me, Your Honor, this is Deputy Mohammed.
Yes, sir.
Mr. Moody, he was turned over to another county.
Yes.
He got picked up earlier today.
Yes. So the next person I have is Mr. McDowell. Mr. McDowell, you've been charged with 2 drug-related counts. I'm setting the bond at $5,000 apiece for those. 1, possession of a weapon during the commission of a crime, setting the bond at $10,000. And 1, possession of a firearm by a convicted felon, I'm setting the bond at $10,000. So you're gonna have a total bond set at $30,000. Do you believe you can post that bond?
Like I have no choice to say that.
Okay. You're gonna have a preliminary hearing date set for May 12th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date. Would you like for me to see if you qualify for the appointment of a lawyer? Are you currently working, Mr. McDowell? Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back. Are you Mr. Randall? Did you say yes?
Yes.
Okay, Mr. Randall, you're charged with 1 count of theft by shoplifting. It's been charged as a felony because of the amount of the alleged theft. I'm gonna set a bond at $5,000. Do you believe you can post that bond? You're gonna have a preliminary hearing date set for May 12th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry?
Yes.
Give me 1 second. All right, you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, you're free to go back. Give me 1 second, Mr. Muhammad.
Yes, Your Honor.
I still haven't received those forms for the ladies.
I will check on them, Your Honor.
Okay, thank you. Are you Mr. Reagan?
Yes.
Sir, you've been charged with 1 count of criminal trespass. I've set the bond at $3,000, but I've set a stay away provision on the bond to stay away from a Kiwana Brantley. Do you believe you can post this bond, sir?
Yes, sir.
And do you understand the stay away provision?
Yes, sir.
You're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning, but that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Reagan. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
You said the bond was how much? 3,000?
3,000, yes, sir.
Thank you.
Okay, you're free to go back. Are you Mr. Ragland? Mr. Ragland, you've been charged with 1 count of battery and 1 count of criminal trespass. I am setting the bond at $8,000. Do you believe you can post that bond? There's going to be a stay away provision on this bond to stay away from Breonna Riley. Do you understand the stay away provision?
If she's not there, because she live in New York, but she's leaving.
Okay, so you're saying that you believe that she's not in the home?
She was leaving the same night. I got arrested.
Would you speak up a little bit, Mr. Ragland? It's hard for me to understand you.
She was leaving. She was on her way to New York the same night
Okay.
got arrested. So she's not gonna be there.
So I would encourage you to, as you're making the provisions to bond out, to make arrangements with the sheriff's department for an appointment, for them to come back to the residence and for you to be there at the residence to make certain that she's not there, because I can't force her out of the residence. And if you were to be there and in the same space, you could be in violation of this stay away provision, okay? Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify, Mr. Ragland. I'm going to appoint a lawyer to represent you. Did I tell you about your preliminary hearing date?
11th, right? March 11th. May 11th, May 11th.
Yes, and that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any other questions for me, sir? Okay, you're free to go back. Are you Mr. Session? Sir, you've been charged with 1 count of trafficking marijuana. The bond is going to be set at $15,000. Do you believe you can post that bond? You're going to have a preliminary hearing date set for May 12th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, Mr. Session. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir? Okay, you're free to go back. Are you Mr. Strong? Mr. Strong, you're charged with 1 count of driving under the influence of alcohol, 1 count of running a red light, and 1 count of operating a vehicle on a closed highway. You're going to have a total bond set at $6,000. Do you believe you can post that bond?
Yes, sir.
Okay. You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Strong. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
You said that bond is for $6,000.
It's $6,000. Okay. Any other questions? All right, you're free to go back.
They got you. Excuse me, Your Honor.
Yes, sir.
The next person, Michael.
Uh-huh.
I believe he also been turned over to another county.
That he's wanted through another county?
Yes, correct. They're the one that got him.
Okay.
Next, Mr. Williams.
Sir, you've been charged with 1 count of driving on a suspended license. The bond is going to automatically be set at $1,500. Are you Mr. Terrell?
No.
No, Mr. Taylor was sent over to another county.
Oh, okay. I'm sorry.
This is
Are you Mr. Williams. This is Mr. Williams. Okay. You're Donald Williams.
Yes, sir.
Okay. Mr. Williams, you've been charged with 1 count of criminal trespass. I've set the bond at $3,000. Do you believe you can post that bond?
Yes, sir.
You're going to have a stay away provision on this bond to stay away from Danielle Williams. Do you understand that?
Yes, sir.
You're going to have a preliminary hearing date set for May 11th, but that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, Mr. Williams. So I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back. Are you Mr. Wright?
Yes, sir.
Okay, Mr. Wright, you've been charged with 1 count of criminal trespass. I'm placing a $3,000 bond on this. And I'm also going to put a stay away provision on the bond to stay away from Deanna White. Do you believe you can post this bond, sir?
I can post the bond, but I can't stay away from her. It's my mom. I have nowhere to go.
So what I have to do in these situations, Mr. Wright, is to place a stay away provision on you. Now, she can contact the solicitor's office and tell them she has no problems with you coming back, okay? And then this will be lifted and you can come back.
Yes, sir, I understand.
Okay, you're gonna have a preliminary hearing date set for May 11th at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
When you don't get read your Miranda rights, to the case get thrown out?
So it's sort of that only applies if the district attorney's office or the prosecutor attempts to have a statement that you made used against you. In situations like this, they really don't need you to say anything because it's a victim. So it's whatever Ms. White says happened is what they will use to prosecute your case.
Okay, but I'm getting charged for this for throwing a hash brown outside.
And I'll say this, sometimes, in my opinion, what happens is the police believe that they got better things to do than come to your house because somebody's throwing a hash brown. So if they're being called out to your house for that, somebody's going to jail so that the next time somebody gets upset, the police are dealing with armed robberies or burglaries rather than a hash brown being thrown. Does that make sense to you?
Yes, sir, I understand.
Okay. Any other questions, Mr. Wright?
Yes, sir. Have a good day, Your Honor.
You too. You're free to go back.
All right, Your Honor, I'm back. This was the last person, and I will have your paper to you within a few minutes. There was misunderstanding, and it's my fault. So I will have it emailed to you immediately.
Oh, okay. No problem. It just makes it, as you see, it makes it a lot faster when I'm able to do that stuff real time rather than hunting and fishing.
With the mistake I did, I sent the mail first because I got them first, so I should not do the second time. So I apologize about that, Your Honor.